Good afternoon. Welcome to the latest in DRI International's webinar series. Today's topic is GDPR and its considerations for professional continuity planners. I'm Lyndon Bird, DRI's Chief Knowledge Officer. For those of you who may not know, DRI is a non-profit that helps organizations prepare for and recover from disasters. Founded in 1988, DRI International has more than 15,000 certified individuals in over 100 countries, and 93% of them in Fortune 100 companies who employ DRI certified professionals. In fact, more individuals are certified by DRI International than by any other organization in our profession combined. In addition to certifying individuals, DRI assesses organizations to determine resilience and offers organizational accreditation as well. We also serve our profession through educational opportunities, including our annual conference, regional events, thought leadership, and webinars like this one. Today, I will start the webinar with a brief overview of the regulation. I'll be followed by Luuk Akkermans and Ovidiu Diaconescu. Following our presentations, we will hold a questions and answer session when we will answer some of the questions posed by attendees. Please submit all questions that you may have through the question feature. We'll be answering any questions that we do not cover today in DRI's blog Drive Europe. Let's begin. GDPR. GDPR is a regulation from the European Union, but many regulations from the European Union have no effect on continuity profession. So why does this one? What does this particular regulation do in terms of our business? Well, first of all, it was launched earlier this year, so it's quite difficult to see the direct effect yet, but it has a lot of ambition. It is a very ambitious piece of legislation from the European Union. It stands for the General Data Protection Regulation, and on that basis, it covers a wide range of different situations. So let's look at some of the key points. Well, first of all, it is a regulation, and a regulation in European Union terms is mandatory. Most rules that are issued by the European Union are called directives, and those directives are open to a high degree of interpretation and may be interpreted in different EU states in different ways. But actually, a regulation which is mandatory has to be applied equally in all European Union states. It applies essentially to personnel data, so data about individuals. But those individuals are European Union citizens, and there are about 400 million European citizens currently, and this regulation applies to any piece of personal data that you hold about any of those citizens. That means that it applies globally. It's not, as most regulation is, just within EU boundaries. And the penalties, the potential penalties for non-compliance with the regulation can be very high indeed. We'll speak a little bit about that later in the presentation. So if we build a little bit on those key points into some other issues, then the way that we have to consider this is that it doesn't matter what your company is, where your company is resident, where it operates. If you employ or contract with any EU citizen, trade with any EU company, or hold any personal data on EU citizens, you must comply with GDPR. And as I said before, this applies wherever the headquarters of your organization is located. The next key thing to remember is that personal data cannot be held or shared without the explicit permission of the individual. Now, this is, of course, significantly different to what, by tradition allows you to simply not opt out. You have to actually opt in. So any piece of information that anyone holds about any European citizen should technically have been opted in, that the person should have agreed that you can hold it, they would understand what you were going to do with it, and they would be able to withdraw their consent. And that consent withdrawal has to be easy and has to be acted upon. So this is quite a dramatic requirement. Another key element of the legislation is that some firms, and some organizations anyway, have to appoint a data protection officer, shortened DPO. Now, this doesn't apply to too many firms yet, mainly those in the public sector or those that have a high percentage of data management, particularly personal data management. But it's likely to be extended to a lot more firms, I would imagine, in the future, so that there's an official person in the organization, a DPO, responsible for the compliance. I suspect that even for those firms that don't have to, by law, have one, it will make it easy to administer the regulation by appointing one. So I'd expect to see quite a voluntary number of people appointing a data protection officer. Firms will have to undertake a privacy impact assessment on all the data they hold. So if you consider that it may even be difficult in some firms to even realize they necessarily have an EU citizen amongst the people that they have data about, then actually the full assessment of what they've got and what data they hold for that person, and getting compliance with that and getting acceptance for that is a massive task. Certainly, GDPR will have teeth. It'll not just be something that you can self-sign off on. It will be audited. There will be ways in which its compliance will be monitored and checked. And although this doesn't exist at the moment, it would seem likely that perhaps in future some sort of certification program to guarantee compliance might be something that could be introduced. So these are some of the very key issues, I think, that we have to understand when we're dealing with GDPR. I said before that the penalties are quite high. Well, in fact, they are potentially very high, but you do have to question the extent to which the authorities will use these. The regulation provides for penalties up to 20 million euros for a single breach of the regulation. For a small firm, which would be a considerable problem for a small, medium firm. But the real teeth in this is that it's up to 4% of global turnover for a multinational. So if you could imagine that a Facebook, Google, Amazon, Apple, Microsoft didn't comply with this regulation and were fined the maximum, then you'd have to realize that the numbers we're talking about are very, very substantial. And the question really would be, could it be enforced at that level in the courts, and how would this play? What I personally feel is that the objective of this regulation is not actually to fine people a lot of money. It is fundamentally to achieve a cultural change in how global corporations view the privacy of data. So in order to stop this presumption that people who collect data can do more or less what they like with it, sell it, buy it, use it in whatever way, that they can't do that in future, that the data belongs to the individual, and that the third parties who deal with it have to have a responsible way of dealing with that. So I think what it is aiming at is creating a cultural change about privacy and ownership of data. So what's happened to date from my perspective is that I've seen relatively little major impacts and no high-profile fines as yet being levied. In fact, to many people, the complaint I hear is they're getting irritated by the number of emails they're getting from organizations that they think it's obvious that there's no problem, or ones they don't know they ever used before, asking can they keep their information, will they opt in, etc. So the initial phase of this is really lots of organizations actually trying to react quickly and trying to get opt-in or to remove you from their databases. So this is causing perhaps a little bit of short-term irritation to some people. However, it is intended, and the hope for is that it'll provide clarity in what firms can or cannot do with your data. At the moment, it's caused probably more confusion than clarity because companies are very worried and they're not totally sure about what they can and cannot do, so they're taking no chances. One candidate we think of that might be subject to quite a large fine, although this is not confirmed as yet, is British Airways, who had a very major data breach shortly after, in fact, the introduction of GDPR, which made them subject to that legislation when this data breach took place. So that is one to look out for. And then there are some issues that people have asked about Brexit and said, well, what will Brexit affect issues in the UK or the EU? We don't know. We don't know, of course, really what's going to happen with Brexit. It's a relatively chaotic situation at the moment. But whatever happens, the UK government have basically stated that they expect to have the same regulatory frameworks as the EU and specifically for GDPR. So I think that will not necessarily be a dramatic issue. Also, we are finding that other countries, Australia, Canada, and beyond, are also looking at could they have similar laws to GDPR so that for trading and reciprocal status could perhaps be granted to improve with trade deals that they have or want to achieve with the European Union. So to date, that is where we currently are. So that's really just an overview of the things for me to get started. We have two excellent expert presenters with us today, and I think that you should enjoy their presentations, and they will dig into the points I've made in some more detail. So, firstly then, I'd now like to introduce my fellow speaker today, Luuk, and he's actually going to present something which is quite consistent with the last point I made about trade deals, which is to look at the impact of GDPR on supply chains.
Well, thank you, Lyndon. Well, welcome everyone. My name is Luuk Akkermans. I'm living in the Netherlands with my wife and two kids in a very small town near Amsterdam. I guess most of you will know where Amsterdam is. I've been in the information security industry since approximately 2003, working in various industries, both commercial with clients such as Alcoa and Maersk, which you know of a small hacking or a malware outbreak last year. And I'm also currently working in some governmental organizations in the Netherlands. I'm an independent contractor, which means that I'm doing or working on projects for various clients at the same time. I am a certified information security auditor and also a certified information security manager, which basically means that from an American point of view, I have the credentials, the knowledge to really talk about the subject. In my normal work, I also provide privacy and information security training for various clients, which is a nice combination of really working inside an organization and trying to build up a new information security and privacy organization, and also helping the people who need to really do the job to give them enough knowledge, enough experience to really get the job done. So that's basically who I am, what I'm doing. And let me start with what we're going to talk about today. First of all, I would like to give you a little bit of background on what the privacy world in the EU really looked like before the GDPR came around. So was it such a big deal, yes or no? And then let me dig a little bit deeper on what is really currently happening, with the GDPR impact when we're talking about supplier contracts. What are the possibilities? What are the constraints? Stuff like that. And also nice, of course, for all the Britons out there, what is really going to happen with the Brexit coming around. One thing I have to mention that what I'm going to talk about is really my view on the situation. So it's not really like this is the Dutch view on the situation. This is really solely my view, what's currently happening with the GDPR. So how did the world look like before the GDPR came around? I mean, for the past years, I mean, there's been some sort of panic in the EU. The GDPR is coming. We have to prepare. There will be huge fines if you cannot oblige to this new rule. And a lot of people didn't really know what they were talking about. There have been a lot of companies making an awful lot of money just because they knew how to spell GDPR. So was it really, a big deal in Europe? Yes, it was a very big deal. And basically for all kind of organizations, government, commercial, not-for-profit organizations, basically everyone dealing with personal data, they are heavily impacted. And mainly because every single piece of information related to a person needed to be assessed to see, is this really personal information? Is this sensitive personal information? And do we have like the right to process this information, either by law, or do we have a purpose in our organization, like are we selling a product or something like that, to really be able to process this information. So what we've been doing basically the past years and what we're still doing is performing privacy impact assessments. So we needed to define, okay, what kind of information do we have on persons? Can we really process that information, or should we stop providing services, stuff like that? And every single organization had to do the same thing. The main reason I think for most organizations to really panic about this was the fines which were coming up with the GDPR. Now they were talking about the 20 million euros maximum, or 4% of annual worldwide turnover, which is a huge impact on most organizations, well, on every organization. The EU really didn't give any guidance, how they were going to calculate this kind of fines. But just mentioning the 20 million or the 4% annual worldwide turnover makes most companies get quite nervous. What we've seen from a citizen point of view is that the last couple of, let's say, 6 to 12 months, we have seen some sort of spam run floating around, your emails, that all those companies who have been sending you all kind of information the past years, they needed to basically beg you to opt into their mailing list, because they've never really done that. And the GDPR really states that whenever you want to process certain information from a person and you want to communicate with that person, you need to have their consent. So all those organizations which have, your email address on their mailing list for I don't know how many ages, they needed to ask you for your consent to opt in to their mailing list. So for myself, I think I've received approximately 70 to 80 emails just from organizations asking me, or called begging, to opt into their mailing list. So yeah, that is an impact not only for us, but also for all those companies who needed to send out those emails. There's one nice example of the fines I was talking about. There's currently an investigation going on the British Airways data leak, which happened, I think, 2 months ago. I've also been one of those being impacted by this leak, as I also arranged some airline tickets through British Airways. And basically, they might get, once the investigation is completed, get a fine of approximately $600 million due to this massive data leak. Currently, they think there's an impact of about 380,000 persons involved in this data leak. So this is a big thing. There's no final call from the EU what is really going to happen there, but this is going to be a very interesting case to see how strict are they going to be dealing with those fines. But there was way more, than just those fines or those opt-ins we've been talking about. There's a lot about compliance, the requirement to report data breaches, basically also the requirement that you have to have data protection officers in your organization, stuff like that. So yeah, I mean, it was a huge impact for all organizations in Europe. But not only in Europe, of course, because once you have a customer in Europe and you're providing services to them, you also have to comply to certain parts of the GDPR. So basically, for all organizations working with Europe or working in Europe, this was quite a big thing. But also, if you look at the world before the GDPR, related to privacy, there have been many laws and regulations in place in Europe, just with some differences between the EU member states. To give you some examples, like I said, I'm living in the Netherlands, so I can tell you a little bit of what's have been happening the past years. We had quite some good laws and regulations in place since 1989. And I think for the past, let's say, 10 years, the control on those laws and regulations have been quite strict. So yeah, we had a good view of what kind of information do we have on persons, stuff like that. So we should have been pretty much prepared. Should have been, because in the end, the GDPR has a significant impact, as the fines and the regulations are going to be way more monitored than before. Then looking at a company like Germany, Germany in Europe has been known for the most strict requirements for data protection for ages. And so way even before GDPR, personal data was assumed private property. So even governmental processes are impacted due to this law. So you can imagine that in most countries, once we're talking about governmental processes, they can do what they like with your data. But in Germany, this was very much limited. One of the examples I've seen there, working for a company called Alcoa, which I think the majority of you will know, aluminum company of America. I was working as a compliance officer for many years. And one of the things of the assignments I had there was to perform a yearly survey on the computer use policy. So basically once a year we were checking out whether the computer use policy of the organization was readable, people understand what we were talking about, and they were complying to this policy. And basically in all countries in Europe we were allowed to do this without any discussions with the country or with anyone. Of course, we were talking to HR to perform this kind of surveys, but it was okay. And the only country where we had difficulties really to get this survey up and running was Germany. We had to work with like the government to really get consent on performing this survey, stuff like that. So it took us about, let's say, 4 to 5 weeks extra to get a survey, which could basically be sent out in 5 minutes, to get this done in Germany, just because we were not allowed to send those kind of questions and to ask for their opinions to all those Germans. So that was quite a thing. So by that time, Germany was already heavily impacted by privacy. So what about the deal to be able to store EU data in the US? Well, we have some regulations there. In the past, we have had safe harbor, which was a valid option until, I think, the end of 2015. And now we have the Privacy Shield, which is the successor of the safe harbor, where there's also some discussions on, which I will talk about later on. So yeah, we have some options to store EU data outside the EU, but it is still quite limited, and I will be talking about that later on. So before we move on to today's main subject, just one more thing about the GDPR. The GDPR main target is really about protecting the rights and liberties of our the persons in Europe. And it also really initiates freedom of data movement within the EU, or what we also call the European Economic Area, as it also includes Iceland, Norway, and Liechtenstein. So this enables companies and organizations to more easily transfer work between countries, also transfer information about their employees, about their customers between those countries. So yeah, I mean, that's a good thing, right? And we're also protecting the rights and liberties of, all those employees and all those customers. So yeah, I mean, that's a great thing. However, when you are implementing this law and this regulation, it is often seen as the brake on various business aspects. I mean, we're asking all kind of different questions. We are slowing down the processes they have. Like information security has been seen the past years, it's the Department of No. Also, the privacy organization is now seen as the Department of No. But is it really like that? So to get your view on this, I try to make a comparison with what Max Verstappen is doing. I hope most of you know who this guy is. He's a Formula 1 driver from the Netherlands, and of course, if I have to say he's the best one out there, just his car is not the best one. But let's compare what he is doing with the GDPR. So Max has a brake, and of course he has the best ever brake. So that enables him to push hard and overtake as he knows his limits and can control his car. So does he want to get rid of the brake? No way, because if he doesn't have the brake, he cannot really control his car. So as he knows where he can brake and where he can push, like the boundaries of what the car is doing, he can really play with the rules. He can play with the possibilities the car offers, and that is basically the same. Looking at the GDPR, and the organization, once you know the play field and you know the boundaries, you can also explore these boundaries. You still know the limit. You know what is allowed and what is not. You can push the boundaries just a bit. That's what Max is doing as well. But you still know if you want to comply to the law, this is really the boundary, and that's the track limits for Max. If he leaves the track, there's like grass or whatever, and he will lose control of his car, or he will be penalized. So that's a thing. So think of that. I mean, the GDPR, of course, it impacts your organization heavily, but it also enables you to explore the boundaries of what is really allowed. All right. So let's move on to the main subject of today. So what is the GDPR impact on the supplier contracts? What's the deal there? I mean, does it make our job easier or more difficult when dealing with suppliers? Let's take a close look. And yes, having the GDPR in place in Europe is making work, from a European point of view, way easier. And then the main thing is because everyone knows what they have to deal with. It's transparent, straightforward, as it applies to all organizations in all EU countries. It's just one and the same all over the place. There are some country-specific customizations, but just very slight. Like for example, the age of majority, wherein basically the entire Europe it's 18 years, and just only in Scotland it's the age of majority is 16. So that's just like a slight difference between the member states. But it's only those small country-specific customizations. In general, it's all the same. So the good thing is that suppliers do know the rules, sorry, but they also have to be transparent in regards to their security strategy, because that's what the GDPR basically requires them to do. So whenever they want to deliver a service in Europe or to European businesses, they have to be transparent. What is their security strategy? What is their security policy? Are they living security? Are they living privacy? And that is part of the contract with the customer. So that's a great thing. We know what we're dealing with if we want to have a service provided. Also, another nice thing to have by default is the right to audit. So whenever you're gonna, from a European point of view, you're going to deal with a supplier, by default, if that supplier processes personal data, you have the right to audit, which basically means you can, whenever you are hesitating whether the supplier is really doing a good job now to protect the personal data, you have basically the right to hire an external auditor and to assess the supplier, which is great. In the past, whenever you want to add something like the right to audit to a supplier contract, this would cost you an awful lot more money. And nowadays, it's basically part of the deal because it's stated in the GDPR. It's part of what we call the processing agreement. And like I said before, it enables free movement of personal data within member states. So that makes it for a lot of organizations quite, easy for their employees, for their customers to work and to travel in Europe. Great thing. But also, there's still a lot of things to do before you can really get into a contract with a European supplier. So how does it work? First of all, of course, you have to determine what kind of personal data will be processed by a supplier. So that's where the privacy impact assessment or the data protection impact assessment come around. Now, all the requirements are stated in the GDPR, and in the GDPR there are also some templates how to perform such a PIA or a DPIA. So that's a good thing. Everybody knows what they're talking about, what you have to do. It's all the same thing. So once you have performed this privacy impact assessment, you are obliged to set up and agree on a processor agreement, or sometimes called data processing agreement. So this is the same for everyone. Also in the GDPR, there are some templates how this processor agreement should be looking like, and there are also the minimum requirements which has to be in this agreement are in the law. So again, this is the same for everyone. So also from a supplier point of view, they know what they have to deal with. It's not a surprise. So that's great. So what is really included in the processing agreement or processor agreement? And this is just a small part of it. So first of all, there are clear obligations or responsibilities for the processor, where some of them even remain effective after contract termination. So it's not like whenever the contract is terminated or the service is being provided by some other supplier, that there are no longer any rules for the supplier. No, there are some rules which remain effective after contract termination. Great stuff. So, like I said before, we have the right to audit. That's by default in this processor agreement. Suppliers have the requirement to notify the customer on data breaches or possible data breaches, and there's even in there within what kind of time frame this should be done. So that's the 72 hours. Then they are obliged to include their security plan in this processor agreement. So for example, Microsoft, whenever they want to provide services to European businesses, they have to supply a security plan in their in the contract as part of the processor agreement. So that's also nice to see what they are doing to protect your data. And also part of this is the specification of the personal data being processed. So when performing this privacy impact assessment, you're also dealing with well, basically creating the specification of what kind of information is going to be either processed or stored in the service the supplier is going to deliver, and that is included in the contract, which also, of course, enables you to regularly update and review the contract. So whenever you're going to expand the service provided by the supplier, you need to take a close look at, are we going to process even more information outside our company? Because then you also have to modify the processor agreement, because it really needs to specify what kind of data is going to be processed. So, looking at all that, it makes it really transparent for both customer and supplier what they have to do. There's a lot of detail, on responsibilities, obligations, which enables, in any case, from an EU point of view, really fast negotiations on such kind of agreements, because it's all written in the law. So, great stuff. Now looking at contracts with non-EU suppliers, like, for example, the US. Are they allowed to deliver services to EU organizations? Of course, they are, but there are some restrictions there. So we have some good options, which are also written in the GDPR, that should or could be evaluated. So there are some things which I put on the list here, which is not a full list, but just the main items. So first of all, the EU Commission have defined or recognized a couple of countries which could provide adequate protection by default. So that's Argentina, Switzerland, New Zealand, and Canada and the US are also in that list. But due to the privacy shield discussion going on, mainly the US is under a discussion. I will give you an example later on of what kind of discussions are going on in EU when dealing with, for example, contracts with Microsoft. There are some model contracts also provided by the EU. It's a set of 3 standard contractual clauses, which can be used to establish a contract with a non-EU supplier. There will be, in the near future, some certification schemes, which will basically enable suppliers to show that they comply with the GDPR. So also in case of transparency, this is a great thing, of course. It's not yet there. There's no real clarity on when this is really going to be available. The same basically counts for the codes of conduct. There will be probably some standard codes of conduct prepared by associations and other bodies representing controllers or processors to show how they comply to the GDPR. But this is just still being prepared. There is no clear guidance on how this is really going to work. So that's still a big question mark, but the GDPR is providing that option in the future. And then we have the main thing for us, in any case, which is the privacy shield. So, privacy shield, the privacy shield framework. It's the successor of the safe harbor. And basically, the mechanism remains the same. It's an agreement between the EU and the US. It provides for the implementation of self-certification mechanisms for US companies, so for US suppliers, committing to some data protection principles. and it's basically the basis for adequacy decisions, allowing processing and transfer of EU personal data to US companies. So, for example, when dealing with Amazon, Google, stuff like that. So it consists of 7 main principles: notice, choice, accountability for one transfer, of course security, data integrity, and last but not least, recourse, enforcement, and liability. The Privacy Shield framework also contains a public list of self-certified companies. You can look it up. I mean, it's available on the public internet. So this list containing all the organizations, US organization being self-certified, enables EU companies to check or to verify whether the company they're probably going to deal with is really working under the framework, the Privacy Shield framework, which is of course great news because again it makes things very much transparent for EU companies to get some US suppliers to provide services like the Amazons, like the Googles, and even Microsoft in that respect. So that's good news, right? But the difficulty is there's currently the past years some concerns about the validity of the Privacy Shield. And for example, the US law still allows secret agencies like the NSA to access data basically whenever they want. There's a lot of discussions going on, and that's also one of the main reasons why the usage of the model contracts when dealing with US companies is still heavily discussed. For example, in the Netherlands for governmental organizations, I think the majority of the organizations still opt for a European supplier instead of a US supplier, even though the US supplier can provide better services, is more cost effective, stuff like that. But as there is still a lot of discussion on this Privacy Shield framework, on the NSA accessing data whenever they want, or trying to push suppliers like Microsoft, like Google, like Amazon to provide them with all sort of data from European citizens. EU companies are really hesitating working with US suppliers, and that's in some respect it's unfair. It's good that those discussions are going on. It just takes an awful lot of time, and now with all the moves to the cloud, this is really frustrating organizations as they do not know what they are allowed to do by law from an European point of view. So yeah, that makes it really frustrating for a lot of companies to get their cloud adoption, their cloud strategy working, as the majority of cloud providers are residing in the US. So yeah, that's a big deal. So one other subject I would like to briefly talk about is this thing what we call the Brexit. Basically, to Brexit or not to Brexit, there's a lot of discussion going on. So what is really, what's happening out there? What is going to happen, or are we going to be impacted? And do we really know what the Brexit is going to bring us when it's executed? I mean, there's still discussion going on. We don't. So is the UK going to be part of the EEA, so the European Economic Area? Are they going to put up something like privacy armor, like the Privacy Shield in the US? Are they going to adopt the GDPR? Seriously, we don't know. So that whole unclarity about the Brexit, that makes it for European companies difficult to get some UK suppliers in providing cloud services, for example, because they don't know what's going to happen within a year or within 2 years. So what we do know is that EU members are already moving services out of the UK, especially, of course, those ones containing personal data, because they don't know what's going to happen when the Brexit is executed. So in all, it's going to be a very interesting time to see what's going to happen once the Brexit is in effect. So in the meantime, we have some interesting issues to overcome. For example, when the GDPR came into effect this May, we have had a lot of US news agencies putting this kind of screens up whenever a European citizen was trying to read, for example, what is the USA Today, as they have to explicitly give their consent on the use of their privacy-related information like IP addresses, locations, stuff like that, as this is part of the GDPR. I think for some of the newspapers we were even not able to read them at all, as you know, those countries, due to the unclarity of the GDPR rules, they just didn't want to provide that service anymore to Europeans, and this is still happening. There's also some other interesting discussion going on in the Netherlands nowadays, and I think it's going to affect the entire EU pretty soon. There have been some discussions in the Dutch government on the use of Windows 10, as Windows 10 is by default sending quite some interesting telemetrics to Microsoft. Even if you only use the base level of telemetrics, it's still, well, there's some information there which could tell you something about the person being behind the keyboard. So that is personal information. So it's impacted by the GDPR. So this discussion is currently limiting the Dutch organizations, mainly the governmental organizations, to adopt the use of Windows 10, Office 365, as we don't know exactly what the GDPR really allows us to do, looking at those services, looking at the telemetrics which are being sent to Microsoft automatically. So this is going to be an interesting case. I mean, if the outcome of this privacy impact assessment is going to be that Microsoft has to change their Windows 10 service, and that they're no longer allowed to send all kind of logs and telemetrics to their organization, this is going to be having a huge impact either on Microsoft or maybe even on the Dutch government, where they are going to make the decision not to migrate to Windows 10 and explore other options. And once, of course, this is a discussion in the Netherlands, this is going to be discussion in other EU countries as well. So yeah, it's an interesting time ahead of us, as we are only now starting to experience the first effects of the GDPR. So yes, it's going to be interesting, and we're going to see what we're heading to. So that's my story for today. If you do have any questions, just let me know, and I'll make sure to give you a nice answer. Thank you. Bye bye.
Thank you, Luuk. We'll now be joined by Ove, who will discuss cross-border data transfers under GDPR.
Thank you, Lyndon. I'm Ovidiu Diaconescu. I'm the co-founder of Alter Ego Technology. We're a company that makes a platform for GDPR compliance for both SMEs and big enterprises. Today we're going to talk about data segregation and cross-border data transfers. And that's about it. I'm sure you'll find some nuggets of information that are really helpful for you. Let's go ahead and start up as lawyers do with a disclaimer that I am not a lawyer. I'm a technical person. I've been coding and working within the technology industry for over 15 years right now. So take everything that you hear over this webinar with a grain of salt, and we will go over the details in the Q&A section if there's something. Always just make sure that you consult with your lawyer and don't do anything that might jeopardize the business. And let's go ahead and start from a moral standpoint. what is the letter of the law and what is the spirit of the law, the way that GDPR was intended. Well, our strong belief is that we wouldn't want other people to do nasty things with our data. I think if you just think about your customers the way and treat them the way that you would like yourself to be treated, everything should be fine. The rest, as the devil is in the details can be sorted out. And just make sure that as an overview, as a mile-high strategy, you don't do things that you wouldn't be comfortable with if they were done to you. So one of the tricky points of GDPR is what do you do with the data that comes in and out of the European Union, and how should that be treated differently from the way that we do with the data that stays inside. What I first want you to understand is that the data needs to be separated. It needs to be, the law calls it data segregation. And that may be a huge set of words and law articles. They all boil down to answering 6 basic questions. Why do you need that personal information, that email, that first name, last name, and address, and everything in there? And I'm sure that all companies have a valid reason for that. Just a couple of reasons would be to do invoicing, to provide customer service. But in the end, there may be a case that there is some data that you don't really need. Some of our customers were libraries or other sort of institutions that didn't really need to know the gender or sexual preferences of various not necessarily customers, but they were using that data to target them better. So in there, that's a tricky case, which we will go in just a second. After answering why you need that data, you need to split it into categories. What sort of data do we have? And broad categories are just fine. We have names, we have email addresses, we have countries of residence, we have delivery countries, and maybe some other information that can be tied to an individual. Basically, data subject, person, can be identified with a subset of data, or maybe something, just one piece of information, like the email address or the IP address for the technical folks out there, or just a social security number. That's just that one piece of information alone is enough to properly define a person. And that kind of ties the what question to whom. And but beside the one piece of information, there could be more. For example, having a first and last name together and address, or maybe just a zip code, is enough to identify a person. But having just a first name is not enough. So the level of protection could be a bit lenient when you don't have a lot of information. Then we go on the second column here. So we talk about where is that data going to go. If it's just going to go within the European Union, you don't need to do any extra paperwork. You don't need to fulfill a lot of bureaucracy, because the entire European Union zone, the entire European zone adheres to the GDPR security requirements. But when that data goes to other countries, and in the case that we're going to go in just a couple of minutes, it's going to go to Turkey and Russia and sometimes China. The data, the third parties in those countries need to implement their own set of security controls and privacy controls. Then the second last question is, how long is that third party, that company, going to store that data? And this question, from a technical standpoint, it cannot be solved, but it can be solved from a bureaucratic standpoint, from paperwork, from the way that you design your contracts. And you just make sure that the processors of that data that live within the other countries, or even if they become a data controller themselves, they have a fixed amount of time. GDPR doesn't allow for unlimited length of time that particular set of information is stored, but you can be a bit lenient to go all the way from a few years, and then just you do another notification to the customers. There is no need to ask consent for making the period longer. The user just needs to be informed. So it could be probably just as easy to get the data for, let's say, 3 to 5 years, then every 2 years just notify the user that for the next 2 years, we're still going to need your data for X and Y reasons. And the last one is technical consideration. Just make sure that the internal systems are secure, are encrypted, and work with your IT department to find the best measures to do that. So once you split the data within categories and following the few questions laid above, then we talk about the way that we collect the data. So do you need consent for that data or not? And consent is one of the things that a lot of websites do nowadays. I'm sure that all of you have clicked that nasty I agree with cookie buttons, which are sometimes necessary, but not all the time, so, or in the way, not necessarily in the way that they are designed right now. Because talking in general, not necessarily about cookies, but having a person's data and their first name and last name could be for lawful reasons. And GDPR doesn't prevent that. It actually encourages you to have all the data that you need to fulfill a contract, to make sure that you are in compliance with the regulation, be it European regulation or local regulation in that country, that could that supersedes any sort of consent that you get from just pressing a button on the web. And after all, it's just a legitimate interest. If you have a company that operates within the medical realm, it's a legitimate interest for you to know about the particular disease that a patient may have. And we have a lot of customers within the medical field that had a lot of questions about where legitimate interest applies or not. And the trouble actually with consent is that so far, when you are getting some information about the user, it was just a subset of information, just the first name, last name. And then over the years, it started getting, the questionnaire started to creep up with other questions. Some of them were for marketing reasons. Some of them were for to better understand the public audience or to better understand the customer. And while some of these questions are legit, they need to be optional. Potential customer should not be constrained to give more information that is necessary to fulfill the contract. For example, if you are saying if you are selling computer appliances, then the potential customer shouldn't reveal his political preferences or other sort of personal information. And because what happens is when a customer may want to withdraw their consent, you could be in a catch-22 situation that he has deleted some information that maybe interferes with the way the backend processes and the backend systems work within your company. So make sure that you're only getting the required set of information, and that is as small as possible, and make everything else optional because it's unlawful to make it not optional. So let's go over a quick case study. One of our customers within the manufacturing realm, they do they have service centers in both around Europe and the neighboring countries that are not part of the European Union. So obviously data gets transferred around. This particular company makes appliances or home appliances, and they build them in a set of European countries, service them all over the European Union and outside of it. But there are also cases where data just gets sent through their to their backend systems and back and forth in and out of the European Union. So coming back to the consent, this is obviously a legitimate interest. The company doesn't need consent to send the data outside if the proper legal requirements are met, and also from a security standpoint that the third parties outside of the European Union adhere to the same security standards as the companies within. And saying that is quite easy. Drawing up the contracts may be quite easy. What we found is that enforcing it on a long term is a problem. And that sort of ties in with data segregation and with the concerns that we just talked about. So we split the process into two parts, a manual part and an automatic part. Just because we have a hammer doesn't mean that every part of the problem is a nail. We don't need to hit it. So there are good parts coming with a software solution, and there are other perfectly valid points coming up with manual process that involves more employees within different departments. And I've sort of laid down here the pros and cons of various solutions. So for example, if in our case, for the company that sends data outside of the EU, if we want to audit the system every quarter or maybe once a year, then those resources may be just a bit higher and would involve having headcount specifically for that. But if we employ a software solution here that makes sure that GDPR is enforced correctly and that consents or that legitimate interest is enforced correctly and that the security controls are enforced correctly, then the software solution is a no-brainer here. However, if we were to extend and apply a software solution to the entire supply chain of the company and to the entire way that factories operate, and factories may be exchanging information, exchanging customer information with the service center, then starting up and just auditing all those endpoints could be quite a challenge in itself. So it would be better maybe to apply a manual process here and start with a few applications and a few automation points, and then maybe go from there. Even go as far as use automation through normal employees, have a junior auditor that maybe does just that. And at the end, we want to consider accuracy. Where do we care a lot about accuracy, and where would things be maybe not as risky if they slip between the cracks? And that accuracy, there are obvious places where we care deeply about accuracy, like orders and order fulfillment. And there are places, and that includes personal information. And there are cases where we don't care that much about accuracy. Maybe within one of the tens of thousands of data sources within the marketing department. There, we just want to make sure that it's enforced. It's all the data rights that GDPR requires could be enforceable, but we don't care that much about automating them since the number of requests is small, and we kind of know from experience that not all the customers require the data at the same time. So we're okay with, from a risk standpoint, to lower the accuracy level and go manual there. And that's about it. Hear you soon. Thank you.
Thank you, Ove. We'll now be transitioning into our question and answer section. If we are unable to answer your question in today's webinar, please be sure to visit drive.drii.org. We'll be posting answers to the remaining questions along with a recording of today's webinar. Our first question is, which part of the organization should own GDPR? Business continuity, IT, compliance? An interesting one. I think I'll take this question myself. Well, it certainly is a compliance issue. But yes, IT are the custodians of all our data, so they have a very big role in delivering GDPR. And when you look at the risk of non-compliance against GDPR, it does have some big business continuity implications. So the answer to that really is that all people are involved. But the question is ownership. And ownership is about, well, what type of risk is this? And to me, this is a strategic corporate risk. And it has to be managed, therefore, at the top of the organization. Now, as I mentioned before, some organizations will have a data protection officer who will run the program, coordinate, and make sure all of this is being done. But for many firms, this is not mandated, although probably many will eventually appoint one. If they do, who does that person report to? Well, I think probably you have to look at this function then in a similar way to any other control function like internal audit. The role will have to be independent of all functional management and report directly into the board or the C-suite management team. It will have to be reporting at that top level. So I think that that to me is really who owns this particular issue. Moving on from that, we'll have another question, and I see we've got another question in, and that question is for Ove. In your view, which industries have specific needs in light of GDPR?
So there are industries that are affected more than others. Some of them, actually, like the medical industry, has already been under a lot of scrutiny, and it already has a lot of regulation that governs the way they interact with patient data. And obviously, that would be a high point. Actually, in the GDPR, there's an article number 9, which clearly identifies the special categories of personal data. And beside the medical one, there are things that involve exactly information that cannot be changed. For example, biometric data. If in 5 years down the road, we have fingerprint sensors just like the iPhone, but on the fridge, that fridge starts to become a really high risk data collector. And it needs to have a huge, it needs to be streamlined better, the way that data is collected through it. But beside the data that concerns our bodies, there's also data concerning our beliefs and about religion, about political alliances or different views. So I would say that if the company processes data that is maybe outside of the normal things that e-shop does, that manufacturing plant requires for service fulfillment, you should better take a look again with your lawyer on Article 9 and have a special set of controls, compensating controls on the risks that processing that data will bring to your business. That's it.
Thank you, Ove. Luuk, the next question is for you. What would you say is the biggest variable or source of uncertainty in the future of GDPR?
Well, great question, Lyndon. Well, I mean, the largest uncertainty, about this GDPR, what's going to happen is basically, I mean, it's a law. So there's a law ever described in detail what you have to do or what you have to oblige to know. So there's a lot of discussion on, the exact implementation of all the rules and regulations stated in the GDPR. There's, it's a huge gray area where companies are assuming, something, while the other, company or organization might be assuming, just things a little bit, different. the past years there have been some white papers, some guidelines being prepared by the EU. There will be more guidelines on specific areas. So that is really where the EU Commission needs to focus on. They need to give us a bit more guidelines, direction on how to basically adopt the GDPR, really get into more details, be more specific on some areas, so there's not a lot of, room for interpretation. I think that is, the main thing where the implementation of the GDPR could be heavily impacted if the EU is not coming or not providing enough details on this subject. Yeah.
Concludes the question and answer portion of our webinar. If you have further questions for our speakers, please enter them now, and we will be in touch with the answers. If you have questions about DRI, please visit dri.org and submit an inquiry, and someone will be in touch with you very shortly. Slides from this presentation, along with all our past webinars and a video recording, will be available online at dri.org. Answers to unanswered questions will also be posting on our blog Drive. I'm Lyndon Bird. This webinar has been a production of DRI International 2018, all rights reserved.